Thank you. This hearing is the matter of case number CA001-2023 before His Excellency Justice Shamlan Sawalehi, Justice Lord Angus Glennie, and Justice Robert French. The appellant is represented by Clyde & Co. and lead counsel is Mr. Nicholas Craig Casey. The respondent is represented by HFW and the lead counsel is Ms. Zoe O'Sullivan Casey.
Mr. Craig, I think it's your appeal. Before we start, there's nothing in the bundles showing the position about the grant of leave to appeal, but do I understand it that the permission to appeal has been granted?
It has. In fact, that has been added at tab 5 of Part A, the permission to appeal, and also the grant of an interim anti-suit injunction pending this appeal. It's all included in the same order.
This is the appeal itself.
This is the appeal itself.
And the interim anti-suit injunction would continue or disappear depending on the outcome of the main appeal. Is that right?
Correct.
Yeah. Thank you.
Yes, I don't know whether any today, as I say, it's at bundle section A, tab 5, and I'm sorry that wasn't included initially in the bundle.
Thank you. Unless any of my colleagues want to ask anything about that, I think we're ready to proceed with your submissions.
Thank you, Your Honour.
I think you can take it we've read the skeleton arguments at least, and the judgment below, and the grounds of appeal, and probably some other documents.
I'm grateful. I mean, what I intended to do is first of all take you through the background that hopefully can be done at some pace, at least in relation to most of it. Secondly, to take you to what we consider to be general principles governing the grant of anti-suit injunctions. And I don't think there is actually going to be a huge amount of disagreement on those general principles. And then thirdly, to make submissions on the 3 grounds of appeal. As you know, the essential question to be determined on this appeal is whether or not the defendants should be restrained from continuing proceedings which they've commenced before the Sharjah Court of First Instance on grounds that their pursuit of those proceedings is vexatious, oppressive, and otherwise unconscionable. So in relation to the background, that's the first part, I propose to briefly describe what the claim is about, which I think you already have fairly a good knowledge by virtue of the previous appeal. Secondly, what's happened in these DIC proceedings, and then thirdly, to look at the proceedings in Sharjah. In relation to the claim itself, the claimant insured the defendant Horizon and its subsidiaries and affiliates under 2 policies of marine insurance, one a hull and machinery policy and one a war policy, in respect of a number of vessels. One of the vessels was the Beta, which is a tanker said to be owned by the second defendant. That vessel was discovered to be missing, and in November 2020, Horizon notified the insurers that the vessel had disappeared. Subsequently, it was discovered that that vessel was in Iran and in the service of the Iranian Navy. And then on the 25th of October, Horizon purported to give formal notice of a claim for its loss under both policies. There was no acknowledgement by ABNIC of that formal notice, and told it that it would effectively revert with its position on coverage before receiving a response in relation to that claim. On the 7th of November 2021, Horizon filed a complaint with the insurance authority.
Sorry to interrupt you. This is the point in a second episode of a streaming series where I hit the button called skip intro. And
fine.
wonder whether, I mean, we're pretty familiar with all that background, and as I understand it, the point at which we pick up is that that you've had there's been a problem in the committee. The committee wrongly found there was an arbitration clause when there wasn't, and you've gone off to a competent or they've gone off to a competent court. being the Sharjah court.
Yes. Well, then I'll skip through the summary of the claim. You know, obviously, all the details of these proceedings and what's happened in those, the decision of Mr. Justice Roger Giles, etc. And we've had the appeal at the end of January this year. But just pausing there, obviously, the consequence of the jurisdiction challenge is that the substantive proceedings before this court have not been able to proceed since they were issued in November 2021. So that's a delay effectively of 17 months. Now, in relation to the proceedings in Sharjah, as you've already stated, they dismissed the IDRC dismissed Horizon's complaint, and then the proceedings were started in Sharjah. The key, I think, is to take you to, because this is very relevant to what you have to consider, the statement of claim in those proceedings in Sharjah. I don't know whether you've looked at it already, but it is at Bundle B, Section B, Tab 3, and starts at page 18.
You'll have to bear with us slightly. We're working with the new system. Just
Yeah,
when
my computer's doing the same thing. It may be because all of us are trying to get on it at once. I don't know.
Now I've got page 18.
Fantastic. Has everybody got page 18?
Not yet.
Okay.
White circle. Sorry. I've got it.
Fantastic.
Yeah.
And you'll see at page 19, first of all, the subject of the challenge is a decision issued by the IDRC to dismiss the dispute for lack of jurisdiction. And if I could ask you, please, to turn to page 26 at paragraph 21.
Sorry, Mr. Craig, you better give me that reference again, because what I turned up appeared to be something which included a reference to what was said in the Sharjah court, but not actually the Sharjah court document.
So what it should be, it's pay. This is the statement of claim filed by the defendants in the Sharjah proceedings, and it's page 26 of 116.
Okay.
I pressed the button looking for it, and I've gone back to my white circle. I'll catch up. Just carry on without me.
Yeah, I think I've got it now. No, I haven't. I've got petition to appeal application. This was
So
Bundle B.
Bundle B, tab 3.
Tab 3, yep.
Page 26.
It's labelled here Exhibit LS1 PDF, is that correct?
That's correct, yes.
Okay, and I want page 26 of that.
Yeah, so it should be 26 of 116.
Yeah, which paragraph you are referring to?
21, starting out.
No, the paragraph which you want us to look to. Which paragraph?
21.
21. Ah, yes, yes. Referral. Yeah.
So do you have that or not? Doesn't look as though
I have it. No.
Well, I have a paragraph 21, which is about the test for granting permission to appeal.
Well, I've got on the grounds of challenge.
Yes,
two
that's precisely. Yes, that's it.
The two plaintiffs. I think what you can do to help us, if the top right-hand corner of every page is a page number 294. Do you have that? And I think we can go to things directly if you give us those page numbers.
I
Top right.
Have those top right-hand page numbers.
301.
Shakespeare legal translation.
Yes.
301.
294.
294.
Okay.
No,
apologies. I don't have that. I don't have that numbering on my pages.
That's the way to use the search tool, apparently. But if it's not on your pages, that doesn't help much. Okay. Do we all have the paragraph you're referring to begins, the two plaintiffs maintain all previously submitted pleas?
Correct.
Yeah.
I'm just checking to make sure, does Justice French have that, or is that a...
I think you can carry on and tell us the text, because I've got a white circle. And
no. I think if you go to tab 3 and there is you can write 301, then that will pick up the page number is referring to. There's a search by page on tab 3 for 301.
301?
Yeah.
Okay.
I don't want to risk doing that because I've got my page.
Make sure you are in section B.
Yes, I did that.
Section B, tab 3, page 301, and do search. That will.
Seems to want to leap all over the place, but I really don't want to hold people up. I can, if there can be a referral to the text, then.
Okay, I'll do that. So it's a section headed grounds of challenge, and this is the grounds of challenge put before the Sharjah courts. And point A is headed misapplication and misinterpretation of the law and ignorance of a substantial defence submitted by the two plaintiffs regarding the absence of an arbitration clause in the insurance policy. And then paragraph 22 sets out the text of the IDRC's decision in connection with the rejection of the complaint for lack of jurisdiction. And it states, and that reason provides, first of all, it says, apologies. In light of the foregoing, and since it's established from Article 5 of the Semi Resolution, which define the issues not within the jurisdiction of the committees, among which is the insurance disputes which are subject to an arbitration clause. In light of the above, and since the parties to the contract have expressly agreed to make the insurance contracts its provisions and application governed by the English law, and the insurance contract pursuant to Article 5, etc., the committee shall not be competent to hear the insurance dispute, so that subject to an arbitration clause, accordingly this dispute does not fall within the jurisdiction of the committee. And then at paragraph 23, the reference by the defendants in the Sharjah proceedings, accordingly, a committee has based its decision of lack of jurisdiction to hear the dispute on that the insurance policy, the subject matter of the dispute, has been determined in its clauses the obligations of two parties of free will subject the provisions of the contract and its application expressly to English law and the arbitration contract.
They were wrong.
Correct. So basically they challenged the finding that Part A is dealing with the challenge to the fact that there was a dismissal on the grounds of an arbitration clause when that wasn't actually what had been agreed. And you can see that it's at paragraph 36 which is the conclusion paragraph under that heading of this, and it's at page 30 of that tab. And then point B is headed as a separate grounds, misapplication of the law and misunderstanding and misinterpretation of the express wording of the policy concerning the exclusive jurisdiction of the courts of the United Arab Emirates. And then it refers at paragraph 37 to the finding, to the submission by the claimant, called the defendant, obviously for the purpose of the complaint, saying that the IDRC should dismiss the complaint by virtue of the fact that the DIFC courts had jurisdiction. And the IDRC said that plea was valid. At paragraph 39 of this statement of case, the defendants identify the jurisdiction agreement, which, as we know, is each party agrees to submit to the exclusive jurisdiction of the courts of the UAE. And then at paragraph 41, this is the statement which I don't think I'm going to take you to many other paragraphs. It says, whereas the courts of the UAE means the federal and local courts in the UAE and does not include the free zone courts, such as the courts of the Dubai International Financial Centre. Then, I'm sorry, do you have that paragraph?
I do.
I've still got a circle, but I've
You're
got
still okay. I'm sorry.
the page. Thank you. You've given me a very clear path through their reasoning.
Okay. And then paragraph 44, which is at page 33 of this statement of claim, it says, accordingly, as the contracting parties do not have any relationship with the DIFC, etc., and whereas the insurance contract, the subject matter of the case is given the exclusive jurisdiction to the courts of the United Arab to hear the dispute, thus the Insurance Dispute Settlement and Resolution Committee and the Honourable Court, i.e. the Sharjah Court, shall have jurisdiction to hear this case. Therefore, the case shall be referred to the insurance IDRSC to hear the dispute, or alternatively, to repeal the committee's decision and oblige the defendant to pay the amount of the claim. So there are two alternatives there. It is asking either for the matter to be remitted to the IDRC, to another committee. Alternatively, it's asking for the Sharjah courts to determine the case on the merits. Now, going back to this point about the meaning and ambit of the jurisdiction agreement in the policies, we say that that is self-evidently abusive to put that question before the Sharjah courts in circumstances where this court has already determined it, and that question is being determined to the extent that, obviously the appeal is extant, but this court is deciding that.
Finally, thanks, Mr. Craig.
You've got it.
It's a long time.
I'm grateful. Then point 3, the further ground of challenge is in the application. Sorry,
Mr. Craig, just to be clear about that last submission, you don't say it would be abusive for the Sharjah court to be asked to hold that it had jurisdiction, do you? Your main concern is that it's being asked to rule that the DIFC court had no jurisdiction.
Correct.
So you couldn't criticize them for asking the Sharjah court to rule that it had jurisdiction under the jurisdiction clause?
No.
No.
But they've gone much further than that. That's the point. They're seeking, we would say, abusively, to have a redetermination of an issue that's already been determined. I'll develop that submission further when I come to it, but that's the essential point. The next point, grounds of challenge, is in relation to the application of English law, which is under heading C, and it says, first of all, not a reason to say that there's no jurisdiction of the IDRC. And at paragraph 53, which is at page 36 of tab 3. And you will see the reference to the fact it refers to the text, etc., and it says it becomes evident to the Honourable Court that the Insurance Dispute Settlement and Resolution Committee is considered a judicial tribunal, and its decisions are enforceable, which in turn confirms the dispute before the IDRC is considered an instance of litigation. Now, that question was put fairly and squarely before Justice Roger Giles on the jurisdiction application. It was said that, and there was Liz Penden's debate, and it was found by Justice Roger Giles that the proceedings before a complaint before the IDRC was not judicial proceedings. So again, they are seeking to have relitigated an issue which has already been determined decisively in that regard by this court. Then at paragraph 54, they essentially say that the court should not apply English law. This is the Sharjah court should not apply English law. And you see that starts at halfway through the paragraph after the bold exhibit number 16. This confirms the Insurance Dispute Settlement and Resolution Committee is considered an instance of litigation, and the committee therefore shall not accept the defendant's plea concerning the requirement to apply the English law. If the court adopts the English law, the defendant, which pleaded the dispute, has to submit a translated copy of the English law. And then 55, the issue related to proving the foreign law is considered one of the most accurate issues, since it's about the application of a foreign law issued by a legislature of a foreign country before the national judge. It's known the task of the national judiciary is to decide on the dispute presented to it by applying the national law. And then paragraph 56, the mechanism of applying foreign law differs from application of national law, etc. And then in the event the party insists on application of foreign law failed to prove the same, the judge shall then render his judgment pursuant to national law as confirmed by Article 28. The law of UAE, United Arab States, shall apply in case it's not possible to prove that there is a governing foreign law or meaning cannot be delimited. And so essentially what's being suggested there is that the court, in the absence of anything else, should be applying local law, so Sharjah law, UAE federal law, rather than DIFC law.
You say in the absence of anything else, I mean, they're recognising there that it would be open to one party or the other to rely on English law, but they'd have to prove it.
They do. But the starting point is that in the absence of anything else, we're going to take our chances that local law will apply. And again, I'll come on to this in a moment. But the point is that there is, and as the judge found in the decision, the reality is that in the Sharjah courts, the local judges will not apply English law or won't take cognizance of English law. They will ultimately apply, or they're likely to apply, UAE law.
When you say the reality is that some factual matter of which we're meant to take notice, or what?
But that yes, I think that's right. I mean that was his view of the. Give me 1 second, and I will pull up the relevant section of the. So it's at paragraph 68 of the judgment.
So which judgment?
Sorry. It's at tab 15.
It's a double negative. Not unlikely that it will not apply.
Correct.
Yeah. Sorry, paragraph what?
68.
Yeah. Yeah.
And then finally, on the request for what's the defendants are seeking is at page 38 behind tab 3, and you will see effectively it's in the alternative to either refer the decision back to a committee of the IDC or to determine the dispute on the merits. So ABNIC, the claimant, filed a response to this on the 9th of August. And then on the 22nd of August 2022, the defendants replied, and this starts at, if I could ask you to turn to page 93 of tab 3 of bundle B, sorry, section B.
93.
It's actually turned up this time immediately.
That's brilliant.
I'm not being as brave.
Or maybe I've got the wrong thing. This shows an index of submissions. Oh dear.
Hold on.
93 MP.
Am I looking at the document that's translated?
It is another Shakespeare legal translation, yes.
It begins at paragraph 3, the defendant alleged.
Yes.
Good. I'm afraid I did it the old-fashioned way of scrolling through. And what is this document?
So this is the reply to filed by Horizon and ABIS in the charge of proceedings on the 22nd of August 2022 in response to what the claimants had filed in the charge of proceedings. And just for your note, you can see that the document starts at page 91 of this tab. So paragraph 5, it refers to what? Sorry, have you managed to find that, or shall I carry on reading some of the detail?
I think you better at least paraphrase.
Okay, I'll do that.
It's flipping me back to section A whenever I hit section B, but
No.
patient and calm.
Okay. So paragraph 5 refers to what the defendants had, so in other words, the claimants in these proceedings had contended. And then paragraph 7 in relation to the submissions made by the ABNIC at that time. And then at paragraph 8 is really the crucial bit. In response to those submissions, the defendants reply, the DRC courts have not considered the merits of the case yet, whereas no merits-related arguments regarding the dispute were submitted, and all submitted pleas are merely formal pleas related to the jurisdiction of the DRC's court to hear the case. Still argument about jurisdiction. And then the two plaintiffs maintain the correct reading of the insurance policy gives an exclusive jurisdiction to the onshore courts to hear the present case, and that the DRC courts cannot be considered UAE courts unless this is expressly stipulated in the insurance policy. And we're fully aware the cost of litigation before the DRC courts is considerably more than the cost of litigation before the onshore courts. The DFC has nothing to do with the case, whether with respect to the parties to the policy itself, or the subject matter of the policy. We do not think the principle of justice and fairness obliges a litigator to pay or spend huge expenses and amounts to defend his interest before the DFC courts, while there are onshore courts that have all qualifications and skills to hear the case at lower expenses, especially in light of the fact there's no relationship between the parties disputing the DFC, particularly there's no discussion whatsoever between the parties prior to signing the policy that DFC courts would have or may have jurisdiction over any dispute. So 2 points there. It's saying no merits determination, and also it's insisting effectively on its point about the DFC courts not having jurisdiction and seeking effectively to have that redetermined. Point B, contrary to what the defendant has maintained, matter not yet been resolved, has no decision on the merits. And then point C, the defendant was wrong when it considered DIFC courts are courts of the state, and their judgments have the same authority of onshore court judgments because the onshore courts cannot be affected by a decision of the DIFC. And then paragraph 9, they maintain that there's no agreement to refer to the DIFC. And then paragraph 15, it refers to the fact that DIFC has not considered the merits of the case. So it's page 97, paragraph 15, and no pleas on the merits were presented regarding the dispute to date. Now, just pausing there, we say that the main reason for that is, of course, the delay that's been caused by the various appeals that have run, which have meant that this court has not been able to get on with determining the merits. Paragraph 19.
Argument now, Mr. Craig, I'm happy to say.
Oh, thank you. I'm sorry that this is proving rather difficult. I think the glitches in the new system obviously are not completely ironed out. And then paragraph 19, which is at page 98, it refers to the fact that the committee's erred in its interpretation, etc. again. And then again, it has the alternative where it says either refer back to the committee or determine the case on the merits. And then at paragraph 20 on, it effectively claims, sets out its case on the merits and claims to have proven why it's entitled to recover under the policy. And then at page 100, where you will see there's a form of prayer where it, in the alternative, it asks for the repeal of the decision or for an indemnity in the amount of 70 million. So that's all I intend to say for present purposes in connection with the Sharjah proceedings. But just to complete the procedural background, in the light of that position being taken in Sharjah, my clients, we applied for an anti-suit injunction on the 29th of August. That application was first heard on an interim basis on the 6th of September, and the court refused to grant interim anti-suit. Then there was a final hearing on the 20th of September, and the judgment was rendered on the 9th of November, dismissing the my client's application for an anti-suit injunction. And that, of course, that decision is, of course, the subject of this appeal. The application for provision of appeal was served or filed 9 days after the decision, and pending the hearing of this appeal, as said, the Deputy Chief Justice granted an interim anti-suit injunction. So that concludes my the first section. I'm now going to turn to what I describe as the relevant framework for the purposes of seeking an anti-suit injunction on the grounds of vexatious and oppressive conduct. And I hope I can do that by reference more or less to a single case, and that is the decision in Star Reefers, Pool Incorporated and JFC Group Limited. It is, and hopefully this bundle C will be slightly more rewarding when it comes to seeking to find the relevant documents, but it's tab 14 of bundle C.
Got it.
Yes.
You have. Fantastic.
It's like playing the pokies here.
Just first of all, just to summarise what this case was about, the defendants guaranteed the obligations of a charterer under 2 charter parties. Those charter parties were governed by English law and subject to an arbitration agreement, but JFC was not a party to the charter parties or to the arbitration agreement. The charterers failed to pay hire when due, and in consequence, the owners started an arbitration in London against both charterers and JFC, although they had no proper basis to start arbitration proceedings against JFC in London. In the summer of 2010, JFC commenced proceedings in Russia, asserting that the guarantees were governed by Russian law, and they sought declarations that the guarantees were not binding. About 4 months later, the claimant commenced proceedings in London seeking payment under the guarantees. And the long and short of it was that at first instance, the judge granted a anti-suit injunction on the basis that the conduct of the defendant in starting proceedings in Russia was unconscionable. Now, the defendant appealed that decision to the Court of Appeal and was successful on that appeal. It managed to overturn the anti-suit injunction. But if I could first of all ask you to look at paragraph 2 of the judgment of Lord Justice Ricks, and a bit like in this appeal, the essential question which arises on this appeal is whether Mr. Justice Tier was right to say the Russian proceedings were vexatious or oppressive. Suggested on behalf of Star Reefers that that finding was an exercise in discretion and no effective appeal can be mounted against it. However, in my view, however, such a finding is an evaluative judgment and a condition precedent to the grant of any injunction in a case such as this, where no exclusive English jurisdiction or arbitration agreement has been agreed between the parties. In this respect, it's analogous to the concept of abuse of process. In both cases, those of vexatious or oppressive conduct and abuse of process respectively, an evaluative assessment has to be made, which is not an exercise of discretion, but on a matter on which there is in theory a right or wrong answer. If the answer is
the High Court of Australia would disagree with that, and so would the Singapore Court of Appeal, that the evaluative decisions have the character of discretionary decisions, and I mean, obviously it's a question as to which approach we take, but that informs the level of appellate review. An evaluative decision is often one on which reasonable minds might differ, as with a discretion, isn't it?
It is. I mean, I think in a way one's dancing slightly on the head of a pin in relation to what is the distinction. I mean, if I can, I was going to take you to the decision of this court actually in. Sorry,
I thought that although the English courts draw a distinction between discretion and evaluative decision, they end up coming to the same approach as saying, but by a different route. And it is, as you say, dancing on the head of a pin.
Yes, but it's, yeah. Sorry, go on.
I was going to say, for what it's worth, I think the Scots courts take the same view as Australian and probably English.
Good to hear.
Sorry, I interrupted you.
No, not at all. But I think that one could get too carried away with saying, well, it's just a discretion, so we shouldn't interfere. The point is that for purposes such as this, when one's looking at the factors that were taken into account, etc., there is perhaps a little bit. It's not just oh well, it was within the reasonable ambit. One has to start again effectively and say, right, were the right factors taken into account, and was proper weight given to them. I mean, just to complete the picture, if I can just refer you to the decision of this court in
Al-Kharafi.
Al-Kharafi, correct, which is at tab 18.
And the way you paraphrased it there sounded identical to the discretionary approach. Have they taken the right account? Have they given the proper weight to things, and so on?
Yes, I mean, so paragraph 3 of the judgment, Justice Cook refers to the decisions on the correct test to apply when there's a strikeout for abusive process, which effectively is, we would say, the same test. Reference to the decision in Oldie Stores, where Lord Justice Thomas stated the decision made by the first instance judge was not made in the exercise of the discretion. There could only be one correct answer to the question whether or not there was an abusive process. Nonetheless, an appellate court should be reluctant to interfere with the decision of the judge where the decision rests upon balancing a number of factors in a broad merits-based assessment. He stated that in the type of a case where a judge has to balance a number of factors, such as that required in deciding whether or not there's been such an abuse, appellate court will be reluctant to interfere with the decision and the judgment reached on the abusive process by a balance of factors. It will only interfere with the judge if he's taken into account immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion impermissible or not open to him. And then you will see at paragraph 6 on this appeal, Justice Cook said, taken into account constraints against interfering with the decision of a highly experienced judge in a matter of this kind, but had come to the conclusion he did err in principle in his application of the test set out in the authorities, did fail to take into account material factors and reached a conclusion which was plainly wrong and not open to him properly to reach. In particular, he failed to apply the Oldie guidelines properly. So in other words, there's a decision reference to the English decision there, and in particular the decision of Lord Justice Thomas, etc. And he did not simply weigh competing factors in a manner that was open to him and arrive at a solution that this court would not have done, but failed to apply the law in a manner which requires this court to interfere with assessment, etc. If I could go back, if I may, to the decision in, just had to find my reference, apologies. Star refills at tab 14. And at page 9, I'm hoping will come up. So this is tab C, tab 14, page 9. And it's at paragraph 26. You will see that Lord Justice Ricks refers back to a decision, his decision in Glencore, but he says, I ventured to summarise the relevant authorities, and he says jurisprudence limited to the conditions under which such an injunction may be regarded as just and convenient. The following conditions are necessary. Threatened conduct must be unconscionable. What is unconscionable cannot be defined exhaustively, includes conduct which is oppressive or vexatious or interferes with the due process of the court. Underlying principle is one of justice in support of the ends of justice, analogous to abusive process related to matters which should affect a person's conscience. Secondly, to reflect the interest of comity, recognition of the possibility of injunction, although directed against the respondent personally, may be regarded as an interference in the foreign proceedings. Injunction must be necessary to protect the applicant's legitimate interest in English proceedings. Must be a party to litigation in this country at which unconscionable conduct of the party restrained is directed. So there must be a clear need to protect existing English proceedings. And then it says it follows natural forum for the litigation must be England, but this, while necessary, is not a sufficient condition. Now, we would say that when considering an intra-UAE jurisdiction, obviously considerations of forum conveniens are not applicable. However, what we would say is the question of whether or not an injunction is necessary is it must be necessary to protect the claimant's legitimate interests in the DIFC proceedings.
Where we're dealing with different courts within one national jurisdiction, as distinct from courts of different national jurisdictions, would you accept that considerations of comity would weigh higher than where you're dealing with different national jurisdictions? We've had this issue in Australia between federal and state courts with overlapping jurisdictions quite some years ago now. It all sort of got sorted out, but in fact, it was often the case that rather than the grant of an anti-suit injunction, you would see somebody ask for a stay in the court, which they sought to persuade was not the court that should proceed, because proceedings were further advanced in the other court, or for a variety of other reasons.
Yes. Well, I mean, in connection with that, I mean, sorry, I'll answer your question on the legal point, but first of all, in relation to what's happened here, we have asked for a stay. We asked the defendants to agree to a stay, but they refused. So that's.
You asked the court for a stay?
We have, but we haven't. But we were refused that application, and so again, that's why we're pushed this.
Okay.
And in relation to interests of comity, in my submission, so you work out, is the conduct vexatious or not? And then you come to the question of comity. And the question is, in all the circumstances, is it appropriate for this court to interfere in circumstances where the court is in another court in the UAE? And in my submission, for the purposes, once you've answered the question, are they abusing the process of this court by proceeding in Sharjah? In my submission, the test isn't any higher as regards whether it's a UAE court or some court somewhere else.
You say you've asked the court in Sharjah for a stay and it's been refused. Do we have that in the papers before us?
I will give you the reference. I think it's in the fourth witness statement of Mr. Sudagar, but I will confirm that with the particular references, if I may.
Thank you.
And then going back to this decision, paragraph 27, Lord Justice Rick cites the decision of Lord Justice Toulson in Deutsche Bank, and there are effectively 6 points which are made by Lord Justice Toulson in relation to the circumstances in which it will be appropriate to grant an anti-suit injunction. I don't think this. I won't read that out, unless there's any particular bit of it you'd like me to draw to your attention. And then at paragraph 30. There was an argument about whether or not there had to be effectively a submission to the English court before you could get an anti-suit injunction, and that was said that's not necessary. But it says, where a foreign defendant pleaded in England does not submit to the jurisdiction, not agree to litigate or arbitrate in England, not obviously easy to visualise how his foreign proceedings will impede the English proceedings, or when an anti-suit injunction will be necessary. Ex hypothesized that English action will not be opposed. Thus, it's been recognised the unconscionability of the foreign claimant is often to be found mainly or substantially in the very reason he's first submitted to the English jurisdiction as the forum where the party dispute would be resolved, and then sought vexatiously to extricate himself from the consequences of that submission, or oppressively prolong or multiply the litigation by commencing further proceedings abroad. Now, we say that's what's happened here, because having invoked the jurisdiction of this court to say that these proceedings were abusive, and having failed in that argument before this court, it has brought the proceedings in Sharjah, where it's trying to relitigate issues which have already been determined by this court.
It's the case is that you've applied for a stay in the Sharjah court, you've been refused that stay, and presumably you invoked similar arguments to those which you would invoke in pursuit of an anti-suit injunction. They refuse you, so you come off to the DIFC court and seek an anti-suit injunction there on similar grounds.
My understanding is that the grounds upon which you can seek a stay are not the same as those upon which you would seek an anti-suit injunction. But again, I'll have to take instructions on that. The grounds for a stay are not the same.
Well, they would cover, wouldn't they, things like the risk of inconsistent judgments and the inconvenience of having two courts deciding or running two sets of proceedings at the same time with overlapping issues, all those sorts of within the one legal system.
Yes.
It's hard to imagine what critical difference there would be between the criteria for the grant of an anti-suit injunction and the criteria for the grant of a stay in this particular setting.
I'll have to take instructions on that in relation to what is the position before the local courts.
Help me on this, Mr. Craig. Sorry to keep interrupting. You've shown us authorities which are well known on the question of anti-suit injunctions. Have any of those cases, I simply haven't read them all thoroughly, have any of those cases raised the point about whether the better cause is first to apply to the foreign court for a stay, as you did with Sharjah, or do they simply proceed on the basis that you can ignore the foreign court?
There's no suggestion that you need to apply for a stay, and indeed the point is that quite often it's said that by taking action in the foreign court, you are seen to be effectively abandoning your right to seek an anti-suit injunction. In this case, what we did was we issued our application for an anti-suit injunction and then sought the stay in the Sharjah courts.
I see. Yeah.
So our first step was because we didn't recognise effectively the in circumstances where we started the DIFC proceedings, our position was, well, it's the DIFC court that should be considering whether or not the Sharjah proceedings should be stopped, and we shouldn't have to appear in Sharjah. So that's our position on that.
Yes, thank you.
And then just to finish off Star Reefers, the Lord Justice Ricks, paragraph 32, this is page 12 of tab 14. He said, can't find that the JFC's conduct was vexatious. His first reason was that Russian proceedings were commenced with a view to frustrating the determination of the dispute in England. This conclusion is unjustified. Nothing JFC could do in commencing proceedings in Russia to frustrate the proceedings. At the time of JFC's issue of its claim, no valid proceedings had been commenced in England. That, of course, is different to the position in this court, where the proceedings have been going on for 9 months before the Sharjah proceedings were started. And then at paragraph 36 of the judgment, this is page 14, the second principal matter relied upon by the judge was the apparent weakness of JFC's case under Russian law. Even on the judge's findings, does not fall into that special category where it can be said the foreign proceedings are based on a hopeless claim. On the contrary, the judge said unable to resolve the issue. He was satisfied, moreover, that Russian proper law applied to the guarantees in the Russian court. And then he says, going on, in the circumstances, the judge appears to have entirely overlooked the circumstance that JFC had a juridical advantage in the Russian court unavailable to it as it turned out in England, namely the application of Russian rather than English law to the substance of the parties' dispute. Unless that juridical advantage can be said to be hopelessly and cynically invoked, it is a legitimate advantage. It's hard to see a party can be said to be acting unconscionably when it seeks a legitimate juridical advantage in a foreign court, etc. Now, what we say is, in this case, they are seeking to take it, that they are hopelessly and cynically invoking the juridical advantage by saying that UAE law should apply. So in this case, unlike in that case, there is an express agreement that English law should govern.
But I thought, sorry, I'm jumping ahead, but I thought it was now accepted by the other side that in Sharjah they would accept that English law applied, but it was for you to prove it.
Well, they're taking
as would be the case the other way around. If in England someone was saying the law of UAE applied, they'd have to prove it. It's a straightforward conflict of laws point.
Well, it's not, because I mean, going back to the point made earlier, I mean, referring back to the judgment, the reality is that by starting proceedings in Sharjah, they're likely to be able to persuade the court there that UAE law rather than English law should be of application.
All right, I can't remember where I read it. Somewhere it said that there was actually agreement now on the part of the other party that English law should apply.
Well, they've basically they sought in the proceeding before Sharjah to say, actually, no, okay, we accept, this is on the 15th of September in a memorandum, that, okay, well, English law does apply, but that's not to stop them from having initiated the process and said English law should not apply effectively, as we say, to turn around and change. They haven't given any undertaking that they will agree that the dispute determined there will be determined as a matter of English law.
Yeah. Yes, I was getting that from paragraph 66 onwards of the judgment appealed against.
Yes. Yes.
Yeah.
And 63, I think. Sorry, I'm looking at the submissions of the respondent.
If I can now turn to deal with the grounds of appeal, and having set up the background in some detail, I'm hoping that I can actually deal with them relatively speedily. I'm going to deal with ground of appeal number 2 first, and basically what we say is that defendants are acting vexatiously and oppressively by asking the court in Sharjah to decide questions which it first asked this court to determine, but which have been determined against it. And those 2 questions are whether the DFC court has jurisdiction and whether the proceedings before the insurance authority constitute judicial proceedings. There's a further authority I need to take you to in this connection, which is the decision in Electrum SA and Vivendi Holdings, which is at tab 2 of section C. And in this case, they're fairly complicated proceedings, and there were 2 questions. First of all, it was a proper interpretation of a no action clause in a bond issue, and then secondly, in the alternative, whether or not there was an entitlement to an anti-suit injunction on the grounds of vexatious and oppressive behaviour. the judge at first instance granted an anti-suit injunction on the basis of the no action clause in the bonds, and also on grounds that the defendant was acting vexatiously and oppressively. And if I can, I don't think I need to take you to much of the facts, other than to say that the defendant, having been in dispute with Electrum, purchased a substantial holding in bonds on the secondary market to assist its position vis-a-vis, or its litigation position vis-a-vis Electrum, and it then started proceedings in Georgia in circumstances where there were already proceedings in England brought by the trustee of the bonds. And if we could pick up at page 21.
Paragraph
78. And you will see that basically there was an application to stop the H1, as it's called, from commencing and continuing proceedings in Florida. Those injunctions were granted. Reference at paragraph 81 to the injunction being granted on the basis of the no action clause, and then on the alternative grounds also for acting vexatiously and oppressively. And then at paragraph 83, categories which indicate vexation or oppression not closed include institutional proceedings which are bound to fail, or bringing proceedings which undermine or interfere with or undermine the control of the English court of its own process, or proceedings which could and should have formed part of an English action. Paragraph 84, application of anti-suit should not be used as a means of obtaining a summary determination of foreign claims. But then paragraph 85, in particular, an injunction may be granted to protect the process of the English court, and in particular to prevent the relitigation abroad of issues which have been or should have been the subject of a decision in England. So in circumstances where you're seeking to relitigate issues in another court, that is a proper basis to grant an anti-suit injunction. And we say equally, on that relitigation point, the DFC court can and should prevent the relitigation of issues which have already been the subject of a decision by the DFC court. And I've taken you obviously to those 2 points in the proceedings brought before the Sharjah courts, and to where they're seeking effectively to have those points relitigated. So I don't need to take you, I don't think, back to them. So we say that's obviously abusive. The second ground of appeal is the finding by the judge that by reason of the fact that the judgments of courts in the UAE converge in the USC, and that ultimately parties can count on a single conclusion, even if effectively the route's undesirable because you've got two different decisions. He said that was a effectively relevant factor. In my submission, that is not a factor which should be taken into account at all. There's no dispute that if two different courts in the UAE reach conflicting judgments, final conflicting judgments, that conflict will be resolved by the Union Supreme Court. But we say that's irrelevant to the question of whether or not an anti-suit injunction should be granted, because the relevant inquiry for whether or not an anti-suit injunction should be granted is whether the party bringing the proceedings in another court is acting unconscionably, vexatiously, or oppressively. Obviously, for the purposes of resolving a conflict of jurisdiction between two judgments, the USC will not consider that question. Its focus will be on the court which it deems properly to have had jurisdiction. And the fact that the USC can resolve conflicting judgments cannot provide an excuse or justification for a party where it's acting vexatiously or oppressively in bringing the competing proceedings. Otherwise, it would allow any party to bring alternate proceedings in another court in the UAE, although its conduct in doing so would be a clear abuse of process of this court. So we say that the judge was wrong to regard that as a factor in deciding whether or not to grant an injunction.
It might be said to be a rather clunky sort of a way of dealing with the issue, but it does put this situation between courts of concurrent jurisdiction in the UAE in a slightly different position from that of the English court and the Florida court, which you took us to a moment ago, where the proceedings in the Florida court might be said to undermine what's happening in England. Here we have, for better or for worse, some mechanism for dealing with conflicting judgment, which is, of course, always relevant to questions of stay and maybe even anti-suit injunction.
That's right. But as I say, one first of all has to look or focus on, is this appropriate what they're doing in terms of decisions which are, and there's no purpose in this. I mean, they don't need, for the purposes of the Sharjah proceedings, to have a finding that the DIFC court is not a court of competent jurisdiction. That's unnecessary. And equally, it's unnecessary for them to have a finding that the that the complaint is a judicial process. So that's why we say it takes it into a different sphere, and therefore one is looking at vexatious and oppression. So I fully appreciate and accept that the point in relation to comity, in circumstances where what's being done is effectively we're entitled to proceed here. And so we will, and we're not seeking effectively to do things which interfere or abuse the process of this court. So that's where we say the difference is.
I wondered when I was reading your note of argument, your skeleton, whether you were elevating this point rather higher than it deserves to be taken. As I read the judgment, the court starts from the position that, as I think Lord Justice Toulson said, or someone said in in a passage quoted in Star Reefers, the fact of parallel proceedings is not per se vexatious or oppressive. And what the judge is doing here, surely, is saying, and what's more, in this particular case, any risk of conflict can be largely overcome because of the appeal process to the Union Supreme Court. Is it any more than that he's saying? And it hardly merits, one might think, a great deal of forensic analysis.
Well, to the extent it is simply saying that there may be conflicting judgments that will ultimately be resolved, that is not something that we dispute.
I think what I'm meaning to say is that may or may not be correct, but the basis on which you seek your injunction is on the basis that the proceedings themselves, quite apart from the issues of law, are vexatious and oppressive. And this is very much a side aspect to a side aspect of that argument.
Yes, I mean, ultimately, we say a factor that was taken into account which shouldn't have been.
Yeah, I see. And going back, if we can, sorry, to your ground of appeal 2, which is you say relitigating 2 points, one about the DIFC court having jurisdiction, and the other about the status of the insurance authority as a court or a judicial body or not. I think you said a moment ago, those are not actually essential to the other side's case in the Sharjah courts. they seem to be thrown in as going perhaps a bit further than they need to. But if the Sharjah court says, for example, that the DIFC court has no jurisdiction, that wouldn't be binding on the DIFC court, presumably, and parties would just continue to proceed along their parallel, non-meeting straight lines of argument.
Well, it wouldn't be binding on the DIFC, but what it does do is create, in circumstances where, as I go back to the point, this is a point that the defendant has actually raised and asked to be determined by this court, and therefore, and having not got what it wanted in this court, it's then gone off and sought to have that same issue determined by a different court, so relitigating that issue. And we say, and that will ultimately, if there is a conflict, then suddenly there is a conflict which shouldn't be there, because it's having taken its chances with one court, it shouldn't be entitled to take its chances with another.
Yeah.
So that's the Sharjah court that look, the DIFC court has held that it has jurisdiction, and we invite you not to revisit that determination in the interests of comity and consistency. Isn't that argument open in the Sharjah court?
I would consider it, yes, that would be open.
Equally, in the Sharjah court, you could no doubt say, well, look, we don't dispute that you, the Sharjah court, have jurisdiction under the jurisdiction clause, as I think you confirmed, and therefore you don't need to decide the point about whether the DIFC also has jurisdiction.
Yes.
Yeah.
That's all I'm going to say, I think, on ground of appeal 1, unless there's anything further I can add. I was then going to turn to the question that the third ground of appeal, which is effectively the factors point. And the first point, or first two points I've already made in the context of the two separate grounds of appeal. We seem to have some
There's a parallel
random whisperings, yeah, parallel proceedings. We say that the judge failed properly to take into account the reality of the defendant's conduct, and it shows no real intention of complying with any order this court makes, and is using has been using applications for permission to appeal as a device to assist in the prosecution of the Sharjah proceedings. Now, the point is, obviously, these proceedings have effectively been on hold for 17 months. Meanwhile, the defendants have commenced the proceedings in Sharjah, refused to agree to stay them pending determination of the jurisdiction appeal, and then sought to prosecute those proceedings as quickly as they could, while saying the Sharjah court should accept jurisdiction because there's been no progress in considering the substantive aspects of the dispute between the claimant and the defendants, and there's been no final determination by the DFC court of its jurisdiction. Now, we say that shows that there is no real intent, that the defendant is really playing games, and is basically not interested in complying with what this court says or does.
The difficulty here is that the judge considered this argument, reached a view that, contrary to yours, that this didn't suggest any oppression or vexation. And do you say he's wrong as a matter of principle, or simply you disagree with him?
Well, we say he's wrong as a matter of principle. Once you actually take, I mean, it's outside the ambit. Once you actually look at what's been going on, we say that point is one which he couldn't have reached.
I see.
The third point is that no explanation or justification has been given by the defendant for why the competing proceedings had or have been brought. Now, paragraph 24, the judge referred rightly to the decision in the Aberdeen Daver.
Paragraph what, 24?
Paragraph 24, it's at page 7 of tab 15, section B. And in the Aberdeen Daver, it was said the burden is on the party pursuing proceedings in the foreign jurisdiction to produce cogent evidence. There is some personal or juridical advantage that will be available to him only in that jurisdiction, that it was such of importance it would cause injustice to him to deprive him of it. Similar point made in Star Reefers, which we've already looked at. Now, the judge went on to say the absence of a juridical advantage in pursuing the Sharjah proceedings was irrelevant because that's normally considered as part of the forum conveniens analysis, which is not of application between courts of the UAE. Now, we say that's not correct because if a party cannot point to a legitimate juridical advantage, it cannot provide justification for those other proceedings. And if I could just ask you in that connection, the decision to look at the decision in Glencore International and Exeter, which is at bundle C tab 4.
Mm-hmm.
And the question in this case was whether the court should impose an anti-suit injunction against 4 foreign ship owners who had commenced proceedings in Georgia, which claimed to arise out of the losses, claim for losses said to have arisen out of the arrest of 4 vessels. And at paragraph 70, the conclusion, page 21, where the ship owners have been able to show no legitimate interest in pursuing their claims in Georgia, where no prejudice has been or could be suggested to them if restrained from proceeding in Georgia, conclusion they've acted against conscience and against the ends of justice is the proper one to draw. The defendants have put no evidence in as to why it's necessary to commence and prosecute the Sharjah proceedings. They have not pointed to any juridical advantage. They have adduced no evidence of a legitimate interest in pursuing the claim in the Sharjah court, and they haven't pointed to any prejudice if restrained from continuing those proceedings. The next point, which is what we've touched on briefly, is the fact that in pursuing the proceedings in Sharjah, the defendants are intending to avoid the consequences of agreeing to governing law of the policies. And on this point, if I could just ask you to look at the decision of Cadre and Astra Asegura, which is at bundle C, tab 6. Now, in this case, there were proceedings in Romania after the English court had determined it was a natural forum for hearing the dispute. And if I could ask you, please, just to look at page 8 of the judgment at paragraph 18. you will see it says there's no good reason for Astra to seek to have the dispute determined in Romania. Avowed aim was to prevent proceedings in this jurisdiction or in Turkey. It asserted no positive case for starting the action in Romania at that time, described this conduct as forum shopping. And then talks about the juridical advantages in the final, it's about 5 lines up from the bottom of the paragraph. You will see, hopefully, the sentence that begins, as I see it, the only juridical advantage which Astra will lose is the chance to persuade the court there that English law does not apply to the contractual relations between the parties. But having regard to Astra's position in this court, that is not a legitimate advantage. On the contrary, by pursuing that case in Romania and not here, Astra are, in my judgment, acting unconscionably, they're acting cynically. Finally, the judge held there was little significance in the order in which proceedings were commenced. And I submit he was wrong to do so because those charge proceedings were commenced 9 months after these proceedings, not at or about the same time as he seems to have thought. So unless there's anything further I can assist with, that completes my submissions on the appeal.
I have on the question of timing, the respondent in their written submissions point to the fact that it was only a few days or maybe a week or two after the committee gave its decision that they started the charge of proceedings. Is that right as a matter of chronology?
Yes, the decision of the committee was on the 7th of, sorry, just give me 1 second and I'll just make absolutely sure of this. Sorry, the 13th of June was the date on which the IDRC dismissed Horizon's complaint, and the proceedings in Sharjah were commenced on the 7th of July 2022.
Yeah. Yes, thank you. That concludes your submissions, does it?
It does, yes.
Yeah. Well, unless either of my colleagues have any questions they want to ask, I think we've been bombarded with questions as we've gone along, actually. But I think what we'll do is have a short break at this stage, maybe initially for a quarter of an hour or so, and then if you can be available, and we'll see where we go from here. Thank you. We have listened carefully to the arguments presented by Mr. Craig on behalf of the appellants, but we are not satisfied that the appellant has demonstrated an appealable error in the reasoning of the judge below. Whether it's a matter of discretion or evaluation doesn't affect our judgment for this purpose. In those circumstances, the appeal will be dismissed. The interim anti-suit injunction will be discharged, and subject to hearing argument, we propose that the appellants will pay the respondents' costs of the appeal and of the application in this court and before the judge below, in an amount to be assessed by the registrar on the standard basis, if not agreed. I say that subject to hearing argument. We haven't formally heard argument on costs, but I can't imagine there'll be any difference between the parties on that.
No.
Thank you very much. Well, that's the order we'll make. Thank you both for your assistance.
I'm grateful. May I ask, whether, or I mean, slightly being cheeky, when we might expect the decision on jurisdiction.
I was about to say that, sorry, I meant to say that before leaving, you can expect it imminently.
I'm grateful.
As am I, my lord. Thank you very much.
Thank you very much, all of you.
Thank you.